Welcome to the Defending Heroes podcast. As always, this is Matt James, attorney and founder of James Defense. This week I've been reading the Saylor decision from the Court of Appeals for the Armed Forces. The basic summary of the Saylor case is that Corporal Saylor, who was in the Marines, was charged and brought to court-martial for allegedly possessing child pornography. Now, during pretrial motions, there was an issue that was raised. The government and the defense argued about whether a minor, for the purposes of child pornography court-martials, means a child under the age of 18 or a child under the age of 16. Now, this is important because the UCMJ defines a minor as a child under 16, and the military judge thought, well, it wouldn't make sense if you could legally have intercourse with somebody who was over 16 but under 18, but you couldn't take pictures. In the end, the military judge decided with the defense that the proper age was, in fact, under 16 for a minor in accordance with the UCMJ. Now, the judge made an error. In fact, it is possible for somebody to be able to engage in sexual intercourse and not take pictures. It's just a gap in the law, as you may say. The proper age for a minor for purposes of child pornography is, in fact, under the age of 18. Now, this wasn't a huge error because most of the child pornography that the government had, according to the Court of Appeals, clearly showed children under the age of 16. Now, the proper thing to do in this case for the government would be to take it up on what is known as an interlocutory appeal. They could have gone to the next level of appellate court and said, hey, look, the judge had it wrong, reverse his decision. They could have moved forward with the case, which is what prosecutors often do, especially if they have a strong case. Now, the government in Saylor decided on a third option. They decided to try to use command channels to influence the military judge. The trial counsel in this case had their boss, who was a lieutenant colonel, call up the military judge's boss to complain about the military judge's ruling. But of course, that wasn't enough for the government. They had to take an additional step. According to the trial counsel in this case, they had heard a rumor that the judge had married his wife when she was 17 years old. Now, there's nothing wrong with that, legally or morally, and this had happened more than a decade ago. Nevertheless, the trial counsel in this case accessed the military judge's personnel file, and they checked his marriage certificate, which in fact revealed his wife had been 17 at the time. The government brought this to the military judge's attention and told him, essentially, that he couldn't be fair because of this, and had the judge removed. Now, leaving aside one's feelings about child pornography, the government's actions in this case highlight what military members can face in a court-martial prosecution. Now, unlawful command influence is considered the mortal enemy of military justice because the military runs on a chain of command structure. And if people start using the chain of command to influence military justice, we will not have a fair military justice system. It's very sad because the government in this case did not need to remove the military judge. They had plenty of images that showed children clearly under the age of 16 years old. But they did what they did anyway. They wanted to remove any possibility of the defense winning in this case. They crossed the line and tried to use command channels and personnel files to get what they wanted. Even worse, the government, when asked by the Court of Appeals for the Armed Forces about their behavior, blinked and pretended that they had done nothing wrong. They seemed to be somewhat surprised that using command channels to influence a court-martial and to access a military judge's records could possibly be wrong. This reveals a disturbing attitude among military prosecutors. Most states and military courts have ethical rules that say prosecutors are supposed to seek justice and not convictions. The trial counsel in the Saylor case clearly crossed the line, legally and ethically. The Court of Appeals for the Armed Forces recognized that and decided to dismiss the case. That's right, they dismissed the entire case. They threw out the prosecution with prejudice, which means that Corporal Saylor cannot be prosecuted at any time for child pornography, or at least not for the charges brought in this case. Hopefully this will make military prosecutors think twice before crossing the line next time. Thank you for listening to the Defending Heroes podcast. For more information, please see my website, defendingheroes.com. Once again, this is Matt James. Have a nice day.